Thank you everyone for joining today's webinar, Digital Accessibility Lawsuits in 2026, what the first half of 2026's legal trends mean for your business. And I'm going to go ahead and hand it off to my colleague, our Chief Innovation Officer, Jason Taylor, who will take us through the agenda and host the rest of the webinar. Thank you.
Thanks, Bethany, and thanks everybody for spending time or spending time watching this after the fact. Um, Essentially, today we're going to cover a lot of data. My voice will typically be communicating what we found with regard to data points in the work that we do around the ADA lawsuit report that we've been doing for 6 years. I typically am always really excited to have a guest that's going to bring the color on the legal side. So essentially, the agenda generally will be we'll sort of try to frame the ADA and why lawsuits are brought under the ADA, but particularly talk about why the volume's so high, and then go into breaking that volume down, looking at key trends that you might well be interested in. And through that process, typically we're going to have John bring legal color behind those numbers and explain why those numbers exist in his experience. And then we're going to try to make sure that we cover at the end what you should do if you get a lawsuit, our practical advice about that, and also what we feel you could do to help mitigate receiving a lawsuit or receiving a second lawsuit. So first, I just want to introduce John. Maybe John, you could just give us a bit background of yourself and your firm.
Thanks, Jason, and thanks everyone. I'm John Magliozzi. I'm a commercial litigator at Davis Wright Tremaine, but I do a lot of representation of retailers, and retailers are certainly one of the kinds of companies that receive a lot of ADA website accessibility claims, and I defend all sorts of discrimination claims. But in today's world, the most common of those is online accessibility.
Thanks, John. A quick note on our methodology. You're going to hear numbers, and if you download the report, you're going to read a bunch of numbers. I think it's important for you to understand how we come about bringing those numbers together. So what we've done, and we spend a lot of time doing this, essentially, there's two broad areas where we see ADA lawsuits being brought today. They're at federal courts, which is across 11 circuits, or at state courts, particularly in California, New York, Florida. So what we do is physically, we actually go and download all of the ADA lawsuits at federal court level. Many of those lawsuits are brought against physical locations, not just digital locations, digital properties. So we filter those out. So we read the lawsuits and we filter out the lawsuits which are brought against websites and apps. And then those are the ones that we follow. So the data is only looking at digital properties that are the subject of lawsuits at federal level. And then we do the same at a very state level. So we actually go to the individual courts where those lawsuits are being filed at a state court, and pull the dockets and look at the dockets every week. So the data is pulled from those particular sources, and then we look to filter and create trends based on tracking that data points. And I think, one of the things that John and I wanted to do was, you may come to this webinar with a sort of light understanding of the ADA. You might come to this webinar because recently you've received a lawsuit, or you've seen that there's many lawsuits being filed in this space under the ADA. I think it's worth, without too much of a legal point of view, or let's say legal detail, just to go through why the ADA, why we're here, and how the ADA is such a broad and powerful law, and unique in its way. So I'm going to have John sort of give some legal color on that. But the things that stand out for me over the last 6 years is that the ADA has been around 35 years. John's going to talk about clearly there were not websites and apps around 35 years ago. So he's going to talk about how has websites and apps been integrated into a law that's 35 years old. But I think the first things you should understand is that it's a very powerful act in the fact that any individual can take action against, and I'm going to talk only about Title III. So there's other parts of the ADA, but Title III is essentially around private entities. Any individual that feels that that they're not getting provided equal access can bring a lawsuit against any company. And because that the law allows not for damages, but allows for remedy. So essentially, I found this problem and I need it fixed. But the most important thing probably is that I can also ask for my legal fees to be paid for. Maybe John can talk about that in terms of why that's a unique why that's unique to the ADA compared to other lawsuits, and what's the effect from a sort of an ability to bring those lawsuits about individually.
Yes, as you said, Jason, the ADA is a privately policed statute. Congress created it so that people who are affected by lack of equal access can vindicate their rights. The Attorney General is not going into every business or going into now every website. Private individuals are, and they bring claims seeking injunctive relief, remediation, as you just said, and they have the ability to recover their attorney's fees. So, like other civil rights statutes, but unlike general litigation in this country, there's a prevailing parties provision, there's fee shifting, and that makes it easy for plaintiffs in the sense that they can find lawyers who are willing to take their cases and do not make any out-of-pocket expenditure. The lawyers simply seek their attorney's fees at the end of the case, in that's facilitated a kind of industry of ADA plaintiffs lawyers. And, to some extent, we may say that's a good thing because the statute was intended to bring into compliance non-compliant businesses. But the sort of downside is that there's also a lot of opportunity to, seek out plaintiffs or seek out law firms who are kind of into the business of ADA plaintiff side work. And also, Jason, as you said, the courts are sort of wrestling with how the ADA applies in the online world because it was passed at a time when it primarily addressed architectural barriers and policy modifications for private businesses. And as I'm sure we'll talk about, some states and some federal circuits have come out differently than others as we're kind of in this laboratory experimentation phase about when the ADA applies online. But the uncertainty has led to the need for most private companies to take the most conservative approach. In other words, to be as accessible as possible, because right now there's some uncertainty about which entities operating online are subject to the ADA and not. So because you can be sued anywhere if you're doing business anywhere or shipping goods anywhere, you're sort of stuck with kind of taking the most conservative approach.
Great. So, I mean, just summarizing that and taking those points, right? So we've got a law, we've got a statute in the ADA that empowers individuals to sue private companies for inaccessibility. We've got a Department of Justice over 20 years that basically established that a digital property is very similar to a physical property. Um, we also have state laws which have sort of come about that mimic that sort of civil rights. So essentially, you've got a state legislator that you can bring lawsuits in, and essentially, what John talked about there, that the original ADA was around people physically turning up to a property, a restaurant, a store, and saying, "Oh, I physically can't get in here, and I can't. That means I can't use the facility, right?" And that obviously would require you to go to that location, and that would, minimize the number of people, number of places that you could go visit. But the internet is completely accessible to anybody. It means that one individual could look to shop for shoes across every single shoe store in America online, and essentially decide that every single shoe store is providing some type of barrier for them, and there is nothing stopping them bringing a lawsuit against every single shoe store. So that's essentially why the ADA is such a powerful statute, and essentially why you're seeing such big numbers. And actually, it leads me into what are the numbers that we're seeing this year. So this year, we're going to see around 6,000 lawsuits. We're on track to 6,000 lawsuits, which is about 20 to 25% increase from last year. There's some nuances here, but I think the first thing that we want to come back to, which is something that John touched on, is that you could imagine this is 6,000 individuals that struggled with doing something online and then went and got 6,000 lawyers to support their claim that they couldn't do stuff online. That is not the profile that we see. And maybe, John, you could talk a little bit about where do these 6,000 lawsuits come from, and the focus around particular plaintiffs and particular plaintiff law firms.
Yes. So to go back to something you said and highlight it, this is a tester industry. We had testers in the architectural barrier world too, but there were only so many properties a tester could go to in a certain geographic region in a certain amount of time. And as you've said, now the ease of access of the internet has completely changed the profile of testers. What we're seeing is really 6 to 10 law firms bringing the vast majority of these claims in a number of jurisdictions, in a limited number of jurisdictions, as you mentioned already, California, Florida, New York. There's a few emerging jurisdictions of Illinois and Minnesota, but we're looking at 20 or 25 plaintiffs who are partnered with 6 to 10 law firms who are bringing these lawsuits. So this is a concerted effort, and we could argue about whether this was, sort of the intent of the ADA or not. My own view is that there are some real accessibility crusaders, and there are some opportunists who are using the proliferation of online accessibility claims to make fast copycat complaints that are barely altered from each other and seeking quick settlements. So it really runs the spectrum. And the ADA has created, this vehicle. And so we have to deal with both kinds of complaints.
Yeah, so just to give people a concept of there, so when John talks about there's a top, there's 10 plaintiff firms. Our data shows about 84% of the lawsuits are brought by the top 10 plaintiff firms. So if another plaintiff firm comes in with a similar focus, or another two plaintiff firms come in with a similar focus, you get about a 20% pop on the number of lawsuits. And that's essentially what you're seeing probably this year, which is a couple of new or let's say more refocused law firms have decided this is an area that they're going to specialize in, and essentially they've come into the top 10. That means you've added about 20% of lawsuits because two of the top 10 are new, and the other guys and the other law firms are still doing the work that they did before. So we don't see that this number is reducing. We see that these law firms are very successful. And we would expect more law firms to see the space of ADA as something that they want to specialize in. So we don't see these numbers going down at all, and I don't think we need to dwell too much on the legal side. But the legal side is very simple, which is websites and apps typically have a number of accessibility issues because it hasn't been a priority for the owners. So it's reasonably simple for a plaintiff to find websites with a range of problems that they can point to. If a defendant wants to argue whether that is accessible or not, they're going to have to spend a lot of money arguing the fact, because there is no specifications in the ADA that allow them to say the tabletop is exactly the right height. There is no technical specifications in the ADA for a website. So they will have to spend a certain amount of money arguing that their website is accessible as it should be. And the plaintiff firms are interested in not taking that too long. They're interested in offering a settlement that would probably be less than what it will cost to argue whether your site is accessible or not. And that essentially is, in a nutshell, how most lawsuits go. John, would you give it a different flavor, a
I'll just
different
add
view?
to it a little to say, you're absolutely right. The ADA doesn't say, here's what constitutes accessibility like the 2010 guidelines do for physical structures. The courts have said, well, we don't know exactly what accessibility is, but we will say that the Web Content Accessibility Guidelines, the WCAG, are accessible. Those are a set of voluntary standards that are developed by the World Wide Web Consortium. And so, we certainly see WCAG as one of the standards that's held up as an aspirational standard. The issue is, as you also said, some of the WCAG standards are almost technologically unachievable, or certainly for your business may not be a priority. I imagine that for most businesses, priorities are making sure that they are actually accessible to disabled users so that transactions can be conducted. So you can get caught with WCAG violations that don't seem to be, frankly, all that material to your customer's experience. And that, I think, is one of the things that's happening over the last 10 years. Companies have become more knowledgeable about their need to be accessible online, but still it is easy to have a dynamic website where there's new product pages or there's changes being made, or simply to have not focused on some of the more technical minutia of WCAG and get a demand letter or a lawsuit that says you're out of compliance.
And we're going to talk about a little bit why we think e-commerce sort of fits that mold more than anywhere else. But back to the sort of focal point, and I think one thing we'd love to get your read on is basically what we're seeing is New York, California, and Florida have always been reasonably up there in terms of places to file. I think maybe you could summarize why you think those three are the most, have always been the most, let's say plaintiff friendly or whatever you want to call it, but basically plaintiff friendly. And now why Illinois is also in that bracket. What separates these four circuits, and then obviously there's state and local options in these areas as well. So
Yes.
what is the profile? Why these four stand out for you? Why do these four are the sort of primary places?
Yes. So here the answer is maybe a little more legal, but I think it'll be easy to follow. California has always been attractive to plaintiffs' lawyers because it's a heavily regulated state. And earlier, Jason, you mentioned the overlay of the state laws on top of the ADA. California has a particularly attractive one called the UNRRA Act that has statutory damages. So remember, the ADA doesn't have any damages component. It's just fee shifting. Well, in California, there's an addition of an actual damages component. The the proliferation of California lawsuits was enormous until both the federal court that oversees that state plus a state court, a state appellate court, both ruled that under state and federal law, the ADA and UNRRA only apply to businesses that are connected to brick and mortar locations. So although there's still an impressive number of California claims, it's actually diminished from what it used to be. New York has been a hotbed because we haven't gotten an appellate level decision yet. We still have a bunch of trial court decisions, most of which have said the ADA applies online just like it applies in the physical world. So if you're an e-commerce retailer, we're going to say the ADA applies to you like you were a store, and that has created a sort of you know hotbed for litigation. There was one decision last year by one of our judges in the Southern District of New York who went the other way, who finally said, actually, I think you do have to be connected to a brick and mortar store. So it's an open issue, and we'll see if our appellate court ends up taking that up or not. And Florida is a high population state. that frankly also probably has a lot of disability users. I wouldn't say it's historically been extremely friendly to plaintiffs like California or New York might be, but we certainly see a lot of litigation there as well. Illinois is the latest one, and the interesting thing there is the firm that's brought the most claims in Illinois and threatens to is actually based in New York, but finds New York, a bigger pardon, Illinois-based plaintiffs to bring those claims. So it's definitely strategic. They are thinking about where they want to try to expand the battlefront of ADA website accessibility litigation. And they're relying on the fact that there is a Seventh Circuit decision, a federal appellate decision that covers Illinois from a long time ago that had a very expansive view of whether the ADA applied outside of physical structures. It actually applied the ADA to insurance policies. So it kind of opened the idea that the ADA can apply more broadly. And that's why I speculate, at least, that this firm wants to try to kind of make new law in Illinois and make Illinois a hotbed. And although it's not reflected on here, I think we're going to see some similar efforts in a few other jurisdictions as well, where there are kind of historical reasons to think that the governing appellate courts will be friendly to expansive views of the ADA.
And a final question on this, John, which I always try to make sure I get across is, so if I run a company and we're not headquartered in these four states, I'm pretty safe, right? I don't have to worry about the ADA that much if I'm not headquartered in these four states.
Right. And of course, I appreciate the softball, regrettably not. So the question of whether you can be sued in these states has to do with whether you're subject to personal jurisdiction in those states. And the courts in the era of the internet and e-commerce have taken a very expansive view. Some of them have said a single sale into those jurisdictions that's the subject of the lawsuit is enough. So if you're based in California, but you're selling into New York, or you're based in Nevada or Wyoming or Idaho, and you're selling into New York, you're doing something that the courts call purposely availing yourself of the New York jurisdiction, selling to a potential plaintiff in New York, you can be sued in New York. And that's why I go back to what I said earlier, which is I think businesses have to be kind of taking the most conservative approach while we still have this legal uncertainty where some courts are saying one thing and some courts are saying another. You protect yourself best by saying, okay, I better be prepared for the kind of most rigorous application of the ADA because you could be sued wherever you're selling.
And then if we go to the next slide, outside of the region, let's talk about sectors, right? And this is, obviously a big number. 80% of the lawsuits are brought against e-commerce. A big chunk are brought against food service industries, but we do see lawsuits across nearly every aspect of, let's say, the industry. But maybe what would your, sort of main reason why you think e-commerce is the primary focus of these types of lawsuits?
Yeah, so I guess I think there are a number of reasons. The first is the law does require that the defendants in ADA cases be something called a public accommodation. A kind of a strange name because it's private companies, but it means they have to be open to the public. That's why it's called a public accommodation. And in order to do that, there has to be some kind of commerce. There has to be a commercial purpose for it. And so e-commerce obviously serves that up easily, right? I can buy something. Secondly, I think there's a lot of e-commerce out there that's readily accessible to plaintiffs and their law firms. It's easy to go test an e-commerce website and see if you can buy something and see if you can put it in your cart and purchase it. And then another reason is that personal jurisdiction idea that we just talked about. It may be harder to argue that you should be able to sue a concert venue that's located in another state because that concert venue is really not offering its services nationwide, right? It might allow you to sell tickets to another state, but you've got to travel to wherever the venue is. There's a little more question about where you could sue. Whereas e-commerce, if you're shipping to that jurisdiction, it is very likely you're subject to personal jurisdiction. So it's low-hanging fruit in as much as, you can kind of sit back with a plaintiff in Illinois or New York and be looking nationwide to sue defendants that are located all throughout the country. So those are at least some of the reasons I can think of, and you may have other observations about that too, but I definitely agree that's the hottest defendant side category.
Yeah, I think I would bring out what you said earlier with, you know, law plaintiffs are looking for barriers, right? Or they're looking for a way to tell a story about how many barriers there are, right? And obviously, e-commerce is one that normally complicated websites. They have a range of features and functions. They're changing all the time. They're typically put together by not just one person, but a team, sometimes different vendors. So there's lots of opportunity for there to be a problem. There's lots of opportunities to find a list of issues to put into a lawsuit. And I also think, back to your point about this being a reasonably focused activity, when you're a law firm and you're filing 10 to 20 lawsuits a week, you need a process to get to those 10 to 20 firms, right? 10 or 20. So you've got to start probably with a list of 50 to 100 and decide out of those which ones you're going to essentially create lawsuits for this week. So, e-commerce is quite easy to say top 20 shoe stores, top 20 apparel manufacturers. So we typically see that this is the trend is around where can you find volume of types of clients and where can you find volume of issues. But to your point, also it's a very simple story for a judge to hear. I wanted to buy a pair of shoes, and if they fix it, I'm going to come back and buy a pair of shoes. That's essentially what they have to say.
Right.
So, that's a very simple story. And if I'm trying to buy a pair of shoes and I went to ten shoe companies and they were all, I decided they all have it in accessibility. Again, it doesn't look like I'm doing anything but following my natural course of my day, and I want to buy a pair of shoes.
Right. And maybe this is a good time to pause and say, Jason, which UsableNet knows very, very well, that these plaintiffs' lawyers are mostly using freely available accessibility automated scanners, things that anyone can access to determine whether they have a viable claim or not. And so this is a very low effort industry. A plaintiff maybe identifies a category of retail or even some specific companies that they feel they encountered a barrier. The lawyers uh, run these freely available accessibility scanners. They come up with errors, and next thing you know, you've got a demand letter or a complaint. Sometimes these demand letters even include the kind of reports from these freely available tools. They are not that sophisticated, frankly. They are not always right. They only test for sort of a category or a subsection of what's in the WCAG standards, and yet it does make it very easy to kind of put together a narrative from I went to the website, I couldn't do what I wanted to do, I ran this report, and there's all these problems, and bring a claim against a defendant.
Yeah, and I'd say maybe today, I'd say we're seeing in the claims maybe 50% of that. We are seeing a little bit more sophistication in probably half of the claims. We are seeing some effort to document what was the barrier, right? Like screenshots of the checkout flow that could not be accessed by a screen reader. We are seeing some additional effort now. I think that's also come about from some pushback from some judges around wanting to see actual harm as opposed to perceived, perceived inaccessibility. But what's the harm? What could you not do? What is the actual harm? So
That's right.
we are seeing a little bit more clarified. But I would tell you that I think even if a plaintiff firm is using a combination of testing tools and maybe someone with a screen reader, they're probably not spending more than 2 hours determining what they're going to put in their lawsuit.
Yes, and
And it,
I go back, Jason, to my dichotomy between the Crusaders and the opportunists, because of the Crusaders, the people who really are trying to change accessibility online are more likely to put that effort in. And you're absolutely right. We'll see videos made that, will receive links to, our clients will receive links to say, here's the barriers I encountered from some law firms and from others. It's just, very, very cookie cutter types of complaints. And you're absolutely right. There has been a little pushback, and I think most significantly there was a case called Gomez in the Central District of California that held that sort of technical breaches that are not central to the functioning of the website. In this case, the scripts for the little links we see at the bottom of websites to go to your Facebook and LinkedIn and Instagram were not accessible. And the court there said, well, that didn't really have anything to do with what you wanted to do on the website, which was add something to your cart and purchase it. And so that kind of de minimis variation or inaccessibility is not enough. So I think you're right. We're seeing some of the plaintiffs' lawyers get a little more specific.
yeah. But I would also say that even if um, the world turns to a place where all the judges say, no, no, we want to see uh, an actual screen reader have a problem on a website, the plaintiff firms will just start to do that. That means they'll take some more time, but there's plenty of opportunity out there
Sure.
for plaintiff firms to document that because there's so much inaccessible websites. So, right now you could argue that they're not doing a lot of work, but if they're pushed to do more, they will do more. And there's plenty for them to use as evidence, I think.
And they'll claim that their fees have increased on the front end, right? And that it is a fee shifting statute, so it will change the economics of these lawsuits if that happens.
Exactly.
So there's risk.
So the next slide sort of just breaks down where we see like the focus of what size companies, and you know I think the thing here to sort of understand is that there's a, and maybe John can talk about this because he's got a lot more experience about, like, as we said, the top 10 plaintiff firms. I think they've each got their own sort of like profile that they potentially might like. But I think, we see still that there's a decent amount of focus on big companies. And that's also where I think we see a lot of repeat. So for those who haven't read the report, I think around about 25% of all lawsuits are companies that got sued before. So maybe we could talk about that as well on this slide, John, which is, what's the likelihood that you might get a second lawsuit? How do you prevent a second lawsuit? So that'd be my first question. Because essentially, I feel like the focus around large companies is this idea that, well, we're going to sue these companies again, right? And then how do those companies, what should those companies do to try to prevent the second lawsuit? I think is probably the thing that's most interesting to me for you to answer. Why are they getting a second lawsuit if they've already got a lawsuit and they're already settled? Why are they getting a second one? And how do they avoid that second one?
Yes. So of course, most large companies, especially after they've received a first lawsuit, but hopefully even before, are now aware that they should be doing something on accessibility. I certainly understand startup companies and small emerging operators of e-commerce, may not be as aware, but you would hope that large companies are, and you would definitely hope that after they receive a first lawsuit, they are aware of their need to be protective of receiving another claim and also to genuinely make their websites accessible to disabled people. Um, Most of the settlements, nearly all of them, are on an individual basis, meaning it's not class action settlements where you get a nationwide release and time to fix your website. There are a few of those, but mostly because of the economics, the settlements on an individual basis. And that means that your your defense, your prophylaxis against additional lawsuits is to fix your website. You're not getting a sort of protection from other plaintiffs with other law firms, and so you must instead make your website accessible. And that's why when I approach these, I always approach them in sort of two silos. Silo one, let's deal with this claim you got, and silo two, let's deal with how you're going to avoid the additional claims. And candidly, that's where UsableNet comes in, because we have to create some kind of program to make sure that we know what we need to do for our website, that we keep the website updated, and that we build accessibility in. I say it has to be baked in, like the user experience, like the design. You have to bake in accessibility. Of course, large e-commerce retailers also usually have very dynamic websites with new product offerings, and I think that's where a lot of the risk comes in. We could make all the changes we want to have a remediated website today, but we also have to make sure that as changes come to the website, we continue to keep an eye on accessibility. And it's a challenge, and it's definitely a place where companies make decisions about how to dedicate their resources, whether they have sufficient teams in place to really continue to keep accessibility at the forefront, or whether it's perfectly reasonable to say we're going to handle accessibility on a periodic basis, and we might see another claim along the way, and that's a cost of doing business. But I think for larger companies, they are aware of the issue, and the challenges are their dynamic websites and keeping up with the changes.
Great. Yeah, and for me, it's always been a little bit like the large people are also, you when you get a lawsuit, they're also public. So once you get one, it's quite easy for someone to see that you've already got sued, and potentially look to see if you settled because your case closed quite quickly. Then that's a potential flag for someone who's looking for an opportunity to come behind on the second one. So.
Absolutely. And the courts have not been kind about what we call mootness arguments, when all you've done for the first claim is agree that you'll get accessible. The courts have said you need to be accessible to say the second claim is moot. You have to have made the fixes, and you have to show a second thing, which is that the accessibility issues are reasonably unlikely to come again. So the sort of the best remediation is one where you get your website accessible, but you also, as I tried to just allude to, put a program in place to keep it that way. And these plaintiff lawyers very much know that their settlement demands are geared toward making that fight not economically viable, right? So we could talk to our clients about making that showing, but we have to answer the complaint, and we have to bring a motion, and we have to get a declaration from the chief technology officer. And frankly, the settlement amounts usually militate toward just, solving the immediate problem and then working on accessibility. It's many clients have decided that's the best use of their resources.
Great. The last data point, which actually sort of stands out for me, and I always sort of just want to make sure we frame it in the right ways. So one of the things that we do when a company's sued, we do a few things. We see whether it has an accessibility statement. We see if it has any other statement around, like, is it working with a company, but also whether it is running any quote unquote type of widget that essentially is meant to be there to help them avoid lawsuits. So, that number continues to go up. It's, probably 20% of the companies that are sued have got some type of accessibility widget. And for those that don't know what I mean by an accessibility widget, it's sort of a accessibility pop-up. It typically manifests itself as a button on a website. And when you click on it, there's a sort of an overlay widget that comes over, which is why they're called overlays in many cases. And they're sort of they look pretty good. They look like they might be doing something, but deep down, they're not really changing the underlying code. But I think more importantly, they don't really do much to help people who are using screen readers. They potentially could help people who are low vision or have different types of disabilities, but screen reader users don't really get any benefit from these types of pop-up and overlays, and they're the users that are suing. So 99% of these lawsuits are sued are made by people who are blind or using some type of screen reader. So the end result is widgets don't really stop lawsuits. They might improve accessibility in some way for certain types of accessibility users. But I wanted your feedback, John, on what you felt, what your sort of advice is around when someone says, well, maybe I can use this sort of add-on that says it will probably help me avoid lawsuits.
Yes, it's really exactly what you said. I think there's definitely some continued risks. First of all, for at least one look, some of the widgets are relatively low dollar subscriptions, and you do sort of get what you pay for. There's one widget that has been criticized by the National Federation for the Blind as not being good enough, and there is a case in which an expert report was put in that says it's not good enough, and there was a case where a court declined to hold that a website claim was mooted because a widget was enabled. That's not sort of a final decision on whether it's good enough or not, but it's not helpful. It's not promising for widgets. I think that they are sort of better than nothing in many cases, but they are not really enough to get you there. Most of these claims require manipulation of the native architecture of the HTML code for the website, and I'll go a step further and say many website developers, third-party website developers, are not really expert at what's required either. The best way to remediate is to partner with an accessibility consultant who specializes in accessibility, like UsableNet does, and understands that the WCAG guidelines and what's required to get there. And I think there's a lot of steps a company can take to mitigate its potential risks, and I certainly understand that every company has resource constraints and personnel constraints, and not everyone is going to be able to throw all of the team and money that's required to do every single thing in WCAG right away after they receive a claim. But you can be strategic about it. And one example is this, getting an audit that does rankings like UsableNet's does of critical, high, medium, and low, and tackling the issues in order of importance. That's one strategy to try to take on the remediation tasks in a thoughtful way, because turning on the widget in and of itself may not be enough given the criticism that's been out there in the courts.
Right. Now let's talk just what you would practically say if you do receive a lawsuit. And I just want to preempt this with our advice normally when companies get lawsuits or call us and say we got a lawsuit. The first thing I say is, stay calm and call someone that handles these types of lawsuits. So, that's really a very practical thing. I think people have heard on this call, right? This is a very focused place. John probably has dealt with, multiple lawyers at the top 10 plaintiff firms. He understands their playbook, what they're trying to achieve. And with that sort of in mind, I think it's good for you to maybe just talk briefly about what you would normally say to a client that approaches you that has received a lawsuit and maybe also mention a demand letter. We haven't really talked about demand letters, but demand letters are letters that you can get pre a lawsuit. Some companies only send demand letters because they're looking for getting legal fees, and probably in the practical world today, there's probably 2 or 3 times as many demand letters as there are lawsuits. So if there's 6,000 lawsuits, there's probably 15,000 demand letters. So what do you say to people who get a demand letter, and then what do you say to people who get a lawsuit? Maybe they're slightly different in terms of how you would handle those. So I think it's worthwhile you covering both of those.
Yes, thank you. I think for a complaint, you absolutely are correct. You need to engage a lawyer, and helpful to engage lawyers who defend ADA website accessibility claims. And there are a number of people, including myself, who've done many, many, many of them, and therefore know what's motivating the plaintiff's lawyers. As I mentioned, some of them are much more granular about remediation, and some of them are not, et cetera. If there's a complaint, then you have to locate counsel, appear, try to make a determination about whether there's any merit to the lawsuit, determine whether you want to follow a settlement strategy or defend. In some courts, there's an opportunity or an obligation to mediate. So that may be an opportunity to try to find an earlier settlement. And otherwise, you want a lawyer who can assess those things that we've talked about, whether you have brick and mortar locations or not, and your jurisdiction would require a brick and mortar location, whether you're subject to personal jurisdiction, whether there are any accessibility barriers that are really stopping people from using the core functionality of your website or not. The demand letters are, in a sense, a little trickier because many clients don't love the appearance of a lawsuit followed by a dismissal. It brings on what you alluded to earlier, Jason, the sort of potential for copycat litigation. Oh, this defendant settled this case. Demand letters are not public, but you also play with fire if you ignore them. And some clients choose to try to handle them with in-house counsel, not wanting to engage in, the expense of outside counsel, which I totally understand. But just because the remediation demands are so specific to what is happening on the legal front and in this industry and with accessibility consultants helping clients like UsableNet does, I think there is, even in the case of demand letter, there's value. There's certainly been some, efforts here and there to take a more innocent approach and say, well, we just didn't know we needed to do this, and so can you give us a pass? And unfortunately, I don't think that has often worked. So the demand letters are usually coming from the same firms as the lawsuits. Some firms always issue demand letters before they sue. Some, it seems, keep a stable of both demand letters and lawsuits going. I'm not sure with some of the law firms what their guiding principles are. And I do think that counsel, can help determine what the best, least expensive course is. And sometimes the legal fees you'll invest in getting that advice, which are very, very modest, will really steer you in the right direction. So I go back to my silo 1 and silo 2. That's silo 1, let's deal with the lawsuit. And then the silo 2 is definitely let's figure out what we're going to do about our website and not seeing another one of these lawsuits if you settle on an individual basis. And that's where you've listed here auditing and remediating your website. And UsableNet is a great example because there's so many different options you offer clients to either get an audit and then do the work themselves, or have help doing the work, or invest in one of the subscription tools that keeps them constantly apprised of when new accessibility issues arise. And different solutions may work for different clients, but definitely picking from one of the solutions rather than doing nothing is required if you want to make sure you don't see another one.
Right. And I mean, I'll just sort of like on the back of that, sort of just closing this out, right? We we've heard about, John talking about like what goes into a lawsuit. So what activity do the firms do to create the content for the lawsuit? That in itself can give you a sort of roadmap of priorities for me. So, if you can imagine that there's companies out there every day going to websites and scanning the top 10 or 20 pages with, one of these sort of generally available free tools. So something like Wave or something like Google Lighthouse, right? And generating a feel of whether that website's, taking accessibility seriously or not, right? That's probably your first area of focus. You can go and do exactly the same thing right now. We actually on UsableNet's website, you can use our free tool. You can test as many pages as you want, and you could send those results to your web team, whether that's an internal web team or an external web team. Say, hey guys, these are obvious issues we need to resolve, and most of those are going to be reasonably easy to fix. They just need to be prioritized. It's not going to massively change your website. And I think that's something you can do quickly and effectively, right? And then the second thing you can do is to essentially For me, deploy a user of a screen reader, which are the people who are taking the website and building the lawsuits, and have those users tell you whether they can use your website or not. Can they do the same things that you expect everybody else to do on the website? So, having someone with a screen reader, whether that's someone that you hire, whether it's you reach out to customers, whether you reach out to family members of staff, whether you reach out to a local lighthouse for the blind that all offer this type of service, you can get a read quite quickly on whether there's major problems. And honestly, when you have someone use a website with a screen reader and there's obvious problems, that helps motivate technical people in the organization to solve those problems. So, combining those two things that we know law firms are doing really help you get ahead, if you ask me, ahead of the law firms. And that helps you prioritize. As John said, we've got very sophisticated programs for sophisticated companies. We help do training for different types of teams. We can integrate our solution as something that we can do for you on behalf of you. But I feel like taking steps which allow you to prioritize and sort of match up what we're seeing in lawsuits will be the most obvious things you can do right now. And they're not heavy lifts. These are things that you can do quite quickly. Now, some of the things that a screen reader user finds may be a heavy lift to fix. But deploying, free testing on your website and a user of a screen reader is not a heavy lift. And that will at least give you an idea of where you stand.
Absolutely.
I know we're getting towards the end of time, so I want to make sure we still keep time for questions. Bethany, I know you normally take over and sort of pick out some good ones, particularly for John, because we've got John on the call.
Someone asked, of the industries listed, what do you anticipate to be the next that may see an increase in lawsuits?
There's really no limit on the imagination of plaintiffs, but I do think that the sort of potential next thing out there is going to be AI or services related to AI. I mean, e-commerce is I think is going nowhere because the personal jurisdiction question we already talked about, and the fact that people want to purchase things and if they feel there's a barrier to purchasing things. But I think other companies that offer services on the internet will have to consider accessibility. The argument for being a so-called public accommodation, a private entity that's governed by the ADA, is not as clear for software as services that are offered on the internet. But I would expect with the proliferation of AI and other sort of online services that people are going to demand that those services be accessible, and we might see that open up. I don't think e-commerce is going anywhere as the number one category, though.
We did have another AI question actually. With the rise of generative AI tools for drafting mass ADA demand letters, how do you see the rules of professional conduct, specifically regarding the duty of competence and a lawyer's obligation to independently verify facts, evolving to handle this hyper scalability?
Hmm. I guess I would say that probably is not unique to ADA claims, all high volume claims, or maybe all claims. We've definitely seen the courts be extremely harsh on non-human checked use of AI in legal briefs. And we've also seen the courts be extremely critical of even pre-AI cookie cutter or copied complaints. There was one kind of now infamous lawsuit, not lawsuit, decision where a judge said that it literally looked to her like the lawsuit had been photocopied. So I think if you come out with huge volumes of new complaints or demand letters that are made by Gen AI, you're still going to be subject to those same criticisms. You absolutely have to have some individualized basis and a good faith basis to bring your claims. But but I think that is likely to be litigated in the future. And I'm not an ethics expert, although I certainly have seen a number of repeat claims on the ADA side that look like they are exactly the same as a prior claim. I
Sorry.
was just going to say I saw two that I thought I could answer easily. One of the questions was about an accessibility statement. I personally favor having an accessibility statement, but making it relatively aspirational. I don't think clients serve themselves well when they say, here is what we comply with and here's what we don't comply with. I
Mhm.
don't think you need to go out there and give that level of detail. I think saying we strive to be accessible, we believe are accessible, and we have a contact if you encounter any barriers is an appropriate way to show your paying attention to the need for your disabled customers to be able to use your website without getting into sort of granular detail that may frankly change over time as you change your accessibility features.
Someone asked, what is the difference between a lawsuit filed versus a demand letter sent out? And then there was a related question, are demand letter and lawsuit settlement fees public?
Yes, so the demand letter comes to the client directly, usually to an avenue of communication listed on their terms and conditions, but it is not a lawsuit. It is not filed in court. It demands action be taken pre-dispute, pre-lawsuit, and so that means that both the demand and any eventual settlement would be confidential. In court, the parties are permitted to keep their settlements confidential, but they could also elect to keep them to make them public if they wanted to, but usually that's not the case. And so what the observer will see is a lawsuit filed and then the case being dismissed. And there's no information about what um, amounts were paid or what commitments were made to, but another lawyer out there could infer that a settlement has occurred, and that's why companies, are very careful about sending messages to the market about how they fight these lawsuits or how they will settle these lawsuits. Someone asked, does it depend on how well you've done on accessibility, how you handle these lawsuits? And I do want to emphasize it absolutely does. The first thing we do when we get one of these complaints is we assess whether there's any merit to it. So I do want to give the assurance that your efforts are not for nothing. Even if you get a claim, after a first claim, you get a second claim. If you've made improvements, that is a basis to argue that the claim has no merit or is mooted. We certainly do take into account the accessibility features.
All right, and with that, this webinar is now ended. Thank you, everyone.